Welcome to the second session for today in this India ADR week. This session is titled War Stories and Lessons from Virtual Hearings in 2020. The session has been hosted by SIAC. It is my pleasure and honor to introduce to you a stellar panel for this session. We have with us today Mr. Chaitanya Arora. Chaitanya Arora is a managing director in the Disputes, Forensics and Investigations practice of Secretariat. He has advised several businesses and funds with evaluation of investments, M&A and joint ventures. He has been appointed as an expert witness in several matters involving post-M&A disputes, joint ventures, construction-related damages, interpretation of accounting and audit issues, breach of commercial contracts and other matters. We also have with us Mr. Dheeraj Nair. Mr. Nair is a partner at J. Sagar Associates. He has been a practicing lawyer since 2000 in courts and tribunals. He has appeared in 20 high courts in India and conducted several domestic and international arbitrations. His core expertise is making strategies and handling multifarious and complex disputes for domestic and international clients. We also have with us today Mr. Dinesh Dhillon. Mr. Dhillon is a partner at Allen & Gledhill and is the co-head of Allen & Gledhill's international arbitration practice. He practices international arbitration and litigation. He has represented multinational companies in cases before the Singapore International Commercial Court, Singapore High Court and Court of Appeals relating to bank, employment, entertainment, insurance, property and shareholder disputes. He has also acted for statutory boards in judicial review cases. We also have with us today Mr. Nakul Dewan. Mr. Dewan is a senior advocate designated by the Supreme Court of India and also a barrister and tenant at the internationally acclaimed Chambers 20 Essex. He is called to the bar in India, Singapore, and England and Wales. He has deep experience and market know-how for disputes and international law advice in sectors such as international arbitration, banking, finance, construction, corporate joint ventures, shareholder partnership disputes, international, including media, telecommunications, energy, and natural resources. We also have with us Ms. Smitha Menon. Ms. Menon is a partner in the International Arbitration and Special Situations Advisory Practice at WongPartnership LLP. Her international and local appointments include being the chair of ICC, Singapore Arbitration Group, and on ICC Commission for Arbitration and ADR. She is also the Singapore Alternate Court member on the ICC International Court of Arbitration. She is on the board of the Singapore Network of the International Women's Insolvency and Restructuring Confederation and served on the Council of the Singapore Law Society. Last but not the least, of course, we have with us Mr. Timothy Cooke. Mr. Cooke is a partner at Stephenson Harwood, Singapore Alliance. He is a barrister and international arbitration partner based in Singapore. He advises on and acts as counsel in arbitration under the rules of the major arbitral institutions with a focus on investment disputes in a wide range of sectors and across jurisdictions such as Vietnam, Indonesia, China, India, Malaysia, and Myanmar. Sends clients in international arbitrations under all the major institutional rules of arbitration. Please join me in extending a warm welcome to all our panelists. And with that, I hand over the session to Mr. Dhillon. Thank you.
Thank you so very much. And it's a real privilege to be here. I thank the MCIA as well as the SIAC for the privilege and opportunity. Virtual hearings, war stories. When you look back at the last year, I can remember April last year, literally I was in court and it was the International Commercial Court that was the platform in that case. And I was before 3 judges, one sitting physically in Singapore, 2 on the screen, one from Australia, another was sitting in Japan. And we managed to get through the hearings. It was one of the first virtual hearings, but there were some teething problems, there were some connectivity issues. And then just this last week, I was back before the International Court again. And this time we were witnesses from Germany, judges on the screen, two counsel in Singapore. and everything went well with witnesses from Germany, India, and China. There wasn't a single glitch. So I guess the technology part is clearly caught up with everything, and glitches are less. But let's hear the war stories of some of our panelists. And we have counsel, we have people with Chaitanya from the expert witness side of things. So we also have people who have experience from the arbitrator perspective. So let's hear from the different perspectives. And let me open first with Nakul.
Thank you, MCIA. Thank you, the SIAC. I mean, it's great that we have an India ADR week and we all get an opportunity of telling you some of our war stories. Well, very similar to Dinesh, but maybe a couple of months before Dinesh's war story began before the Singapore International Commercial Court. Well, I did what I would say was the last Singapore Court of Appeal matter, where one of the judges was in fact being attended the hearing virtually, only because at that time, Singapore adopted what was called the Business Continuity Plan, not to have all their judges sitting in physically. Took a flight out of Singapore, coming back to India, thinking I'll spend 2 weeks here with a couple of court cases and head back to Singapore for a hearing. And then, well, we all know what happened. I mean, I couldn't go back to Singapore all the way until December. Now, why December becomes interesting is this. The SIAC asked me sometime end of November, early December, whether I would be an emergency arbitrator. And I looked at my calendar and I said, well, I've got a scheduled departure for Singapore. I've got 14 days of quarantine in Singapore, which means I'm going to be locked up in a hotel. This sounds like a good time to do an emergency arbitration application because I've got the time to read, I've got the time to do a hearing and pass an order. And I thought I had it beautifully timed. Very constructive use of time for my quarantine period. Get into Singapore. Singapore has a 10-day mandatory requirement for getting a swab test done. My hearing is scheduled on 2 days after this mandatory requirement. I go in for a swab test, come back, next afternoon, get a call from the government saying, you're positive. Now, I am hale and hearty. I am sitting there at 3:30 in the afternoon saying, I have a hearing starting at 9 in the morning the next day. I am declared positive. Singapore government's going to come in, take me over first. Everything that has to be done is now going to be laid out for me. But what do I do about this hearing? So I actually spoke to the Ministry of Health and I said, I have a hearing tomorrow. I don't know what you want to do with me, but you certainly need to give me 4 hours more to finish reading up. And they said, very well, I mean, since you're in isolation, it doesn't matter whether we pick you up now or we pick you up 4 hours later. So they gave me 4 hours to read up, get ready for the hearing. Somewhere around 8:30, I was in an ambulance going down Orchard Road, taken to Tan Tock Seng Hospital, which has the National Infectious Disease Center. Doctor comes and meets me and says, you're looking hale and hearty. I said, I am hale and hearty. So she says, listen, we've got to carry out a number of tests. I said, do whatever you want to. But at 9 in the morning, I need to start this hearing. By which time the SIAC was also involved because I told them what had happened. And they asked me whether I was healthy enough to do the hearing. And I said, listen, I'm as healthy as it gets. So we actually had the Singapore government mechanism coming in and doing all kinds of tests, getting ready with results, everything before 9 a.m. just to make sure that I was going to be able to conduct a hearing. And by 8:30, I was told the next morning, guess what? It was, yes, there was a COVID positive result, but you also have a COVID negative result. We've done an antibodies test. Your serology shows that it must have been a past infection which you had. We don't know when, but significantly much earlier in time. We are happy to release you. And then I said, no, but don't release me now. I have a hearing starting in half an hour. I now need to do this from the hospital. And they'd actually ensured that I had a place in the hospital to conduct the hearing. And I sat and did a hearing from 9 till 12:30, finished the hearing, finished typing out the award, sent the award in the evening, and I said, now I'm very happy to be discharged and I can go home. And the SIAC scrutinized the award, sent the award back to me the next day after scrutiny. I relooked at it and I said, I'm now satisfied with my decision, and we issued it. So that was one experience, Dinesh, that I had as an arbitrator. I've had other experiences as counsel. I've done a couple of trials, but I think let somebody else step in, and I will step back in if I need to talk about some other interesting experiences that I've had.
Thanks, Nakul. That's certainly one that you'll remember for a lifetime, without a doubt. and thankfully you're a sole arbitrator. Otherwise, your decision, could have been split like your COVID ruling. Okay. So perhaps now I can open it to Smitha. Smitha, any war story or
Thanks, Dinesh.
perspective you want to share?
Yeah, well, actually, I was going to talk about pre-hearing preparation, but I think Nakul's point makes it very clear that all the preparation in the world, I mean, no matter how much you prepare, you've got to be flexible to deal with anything that could crop up on the day or for a hearing. But one of the things I wanted to just comment on was how we've never ever had it so good, in the sense that it was never in our control, the environment in which we do a hearing. So I used to actually find the courtroom quite uncomfortable. I felt that the height of the rostrum was wrong. Depending on what shoes you were, it was never the right height for looking up, looking down at documents. I felt I didn't like the chairs. I mean, basically nothing was as comfortable as my own chair at home. And the same thing with hearing rooms. I mean, obviously Maxwell Chambers has amazing hearing rooms, but whether you have an arbitration hearing in a hotel, conference room, or elsewhere, I think we've never really thought about how this COVID-19 has given us an opportunity to truly control our environment. And I've noticed how a lot of lawyers who are clearly much savvier than I am have really taken this to a very useful extreme and made the environment work for them. And it's actually a very important point, because we prepare so hard for our cases, but we should spend the same amount of effort, or at least some of that effort, preparing the battlefield. Because if you control the battlefield, it makes it so much easier for you to control the hearing. And we all know that that helps a lot in getting things moving the way you want it. So just a few things I wanted to share that I've seen. The first thing is about the physical background and location. A lot of judges, and I think some tribunals, they don't like virtual backgrounds. They don't like filters. I think the cat video was one reason why. But generally speaking, because a lot of tribunals don't like people using virtual backgrounds, it's very important to be aware of the background, the actual physical location from which you're taking the hearing or you're conducting the hearing from. And I think recently, because it's been a year on since COVID began, there's been a lot of information out there on the internet. I think some judges in the US in particular have complained about how counsel have been doing their hearings from their bedrooms. And I think one judge wrote a very angry diatribe about how he had several lawyers appear before him while they were still in bed, one still under the covers. So I mean, things like this, which are really easy things to overcome, they set such a wrong impression. I mean, we would never turn up to court half-dressed. We would never turn up to a tribunal, to an arbitration hearing looking anything other than, fully ready to take it on. So just a bit of effort on the location is something that surprisingly people still trip up on. I was in a hearing last month where there were various parties involved, and one of the juniors who wasn't speaking, I think it's a junior from one of the teams, he didn't have a virtual background because the judge didn't allow any virtual backgrounds, but he was taking his laptop was on a desk in his bedroom, and he had the angle of the camera basically showed his bed, which is very, very badly made. So that's the first impression. But that was overshadowed by his large collection of teddy bears. So it was extremely distracting. And you could see that, I mean, just from the views, from the faces of some of the expressions of some of the other people at the hearing, that everyone had clocked that. And it was just distracting and it was unnecessary. Also, I think it created a very poor impression of this really unfortunate associate who didn't even get to speak in the hearing, but yet made an impression on everyone, including the judge. And moving on from stuffed animals to the real thing, I've had hearings interrupted with dogs barking. I think that's quite common. I've also disrupted, luckily not a hearing, but a Zoom meeting with my own animals. I have got chickens and I had roosters crowing. It turned out to be quite a good thing, because it was a negotiation with the other side. And the other side was posturing quite a bit. So the sound effects, though unintended, from the roosters crowing actually sort of added a bit of humor to the session. And one of my, a lawyer I was talking to a few weeks ago, and I was saying, tell me some of your war stories from virtual hearings. He had a very good one. He was saying how he was before a rather strict judge who shall remain unnamed. And there were a lot of shrieks coming in the background, and the judge stopped the hearing and said, do you have exotic birds? Because I've got exotic birds too, and they can be quite loud. You may want to move somewhere else to conduct the hearing. And he had to sort of like shamefully reply that no, he didn't have any exotic animals. He just had 2 sons below the age of 5. So these sort of things, they disrupt the hearing, and sometimes it's taken in good humor. But I think in every one of those instances, it does sort of create a less than professional impression. So my comment is physical location and background is something to be mindful of. And even though it's been a year, it's still something that people trip up on.
Thank you, Smitha. That was very interesting. And I think you raised an important point about that actually goes to the heart of one of the questions I think I'll be bringing up later as we discuss some issues. But I put it this way, I mean, I think when COVID hit and we all had work to do and go on, we all wanted to make sure that, thankfully we have technology so we can continue to dispense justice. But at the same time, if we do it wrong, are we dispensing with justice? So in the sense that your examples you gave, I think some situations, if there's dogs barking, your house is too small, there are kids at home, is it really conducive to get the hearing done, and so on? And as far as funny stories go, the ones you mentioned especially brings to mind one of the first ones I heard early last year. I don't know if you heard about the one to do with the Supreme Court of the United States, where the hearing was going on, all very solemn, and suddenly there was the sound of a flush. So up to this day, I think the mystery has not been solved. Where did that come from? But I think, yeah, these are some of the teething problems that have been overcome. Now let's shift the perspective. Chaitanya, from the perspective of an expert witness or someone testifying, how has the experience been?
Thanks, Dinesh, and thanks to MCIA and SIAC for this opportunity. Smitha raised a very important point about some of the lackluster episodes that have happened during our transition to a virtual world. From a practical perspective, I think sometimes people forget there is still a hearing, it's a trial before a judge, and the formalities of being in that environment are still very much relevant. Even though it's not a horseshoe platform anymore, we are everywhere on 2 dimensions, but we still need to respect the sanctity of the decorum of the process. So from an expert's perspective, I think one of the challenges I faced in particular was a lot of the work that was already done. I mean, reports were filed, proceedings were scheduled, and hearings were planned, got modified to a virtual platform, and the entire body of work needed to adapt. It needed to be structured again and reformatted for it to be displayed, instead of being used in a format where you can flip through pages and use bundles. Tribunals and councils alike were using virtual bundles, and some of my reports had to be redone in a way that can be more user-friendly for the purpose of being used in a virtual hearing. And that is, it sounds rather straightforward, and it's a very time-consuming process when you have to do something to adapt to a virtual environment. So that's the first challenge we faced when we started to move into an entirely virtual world. The other ones that I think many of the speakers on this panel and those listening in would have perhaps experienced is the requirement of flexibility. I mean, a lot of these hearings are involving folks who are not sitting in the same time zone or same geography. And flexibility becomes key, especially from an expert's perspective, because often we are at the tail end of the hearing called in, and sometimes we are faced with experts and others who are not in the same time zone. So starting with accommodating those situations, which sometimes require you to pull the short end of the stick and be awake at 3 a.m, have happened for 2-week-long trials. So you've got to reorganize your day so that you are, awake and alert at the time when you are required to give evidence. And that requires some thinking about and some planning and some shuffling around of other appointments. The third thing that I think was a major hurdle that we had to overcome was the preparation time. The way we used to prepare for physical hearings with counsels in the same room, conducting our trial exercises throughout the day, had to be changed quite significantly, particularly in those cases where counsels and experts were in different geographies. So one of the challenges I think a virtual platform throws out is the ability of participants to stay focused. And that time is condensed to anywhere between 2 to 3 hours, depending on individual capacity. Instead of previously, when you could go on for 6, 7 hours in a physical hearing, in a physical setting, and conduct the preparation. So often the prep time was condensed to 2 to 3 hour long blocks and had to be done in a manner which was a lot more in need for flexibility. And in one particular case where my instructing councils were in North America, we ended up in a situation where they would conduct their prep right before I went to bed and then right after I woke up, just to sort of keep the continuity. And if my experience is similar to others, the time in between going to bed and waking up is not one that can give you a sound sleep, because you're constantly thinking about what's next tomorrow, what's next in the next set of questions that they'll throw out. So it really impacts your body clock and your ability to keep going. But I'll pause there and let others chime in.
Thanks, Chaitanya. That's really helpful. And perhaps now I can turn to Dheeraj.
Yeah, hi, Dinesh. Thank you so much, and thanks MCIA and CIAT for having me here. So I would completely agree with what Chaitanya said. In fact, we've just in the middle of an arbitration where we are actually dealing with 4 continents, because the arbitrators are sitting on a different continent. The opposite side is in a different continent. I'm sitting in New Delhi, and we're having this very interesting arbitration, and the time zone becomes a very, very critical part, because unlike if you're all in the same venue and we're participating, it kind of gives us that advantage, at least your body clock adjusts to another time zone. So this is a big challenge. And another thing, which I think it's more of a war story for me personally, which Smitha mentioned a while ago. For the first time in my life, my 2 boys saw what their dad does, and we were sharing the same professional place, and they're like, "Oh, you really go through all this? You have to read all this? And if you have to read all this, I'm not becoming a lawyer, because we're reading enough in school." So the first time, initial days were very, very critical for us, because we were all sharing the same space and the same Wi-Fi, and that became the war zone, because the kids would say, "I need that Wi-Fi more. I need the Wi-Fi more." And of course, besides that, I think the ability of our arbitrators, especially when I look at it from an Indian perspective, a lot of us do end up appointing a retired Supreme Court of India or retired High Court judges for our ad hoc arbitrations, including our institutional arbitrations in India. And one of the things that I've seen is that there was a big challenge initially for these arbitrators to adopt to technology and to figure out how to maybe working on Opus or any such document retrieve services. And we had to kind of figure that out. But I'm very happy to say that over this entire COVID year, we have arbitrators. We've dealt with arbitrators as a firm who are 80 plus, and they are superbly adjusting to technology. And it's such a beautiful thing to see that all of them are now very, very happy about things. Of course, all those the health moving around, the dogs barking, etc., is now kind of reduced. It still is there, but it's kind of reduced. And yes, I think it's been a wonderful experience. The advantages, of course, there with respect to a major advantage has been the time and the cost, which I'm sure Dinesh will take us through that in terms of the session today. And also the fact that we are now adapting. All of us are literally adapting. And most of us probably, at least the sector I move around, are actually seriously thinking that why can't we do this even when we're free from COVID? And this works for all of us. It's actually quite advantageous.
Yes. Thanks, Dheeraj. And I think you ended off on the point that I intend to come back to. What do we keep? What do we not keep? How have we learned from this? And yeah, the cost issue is part of that package. And before we get there, though, let's hear from Timothy.
Thanks, Dinesh, and thanks to the SIC and MCIA. Smitha mentioned earlier animals that intrude on hearings. I have to say, very early on in the lockdown, my 2 dogs gave some extensive submissions in an application I was trying to make, but it appeared to go very well because I won the application. So often my dogs, if they want to speak, then I don't have a problem with it because it might help me. But in a case I did towards the end of last year, I had an interesting problem that arose. I was in the middle of cross-examining a witness, having examined him for most of the day, and we took a break as one of the sort of hourly breaks that the tribunal gave. And we were in the process of discussing where we got to in the examination and what was going to happen next, when one of my team members suddenly out of nowhere shouted, "Everybody stop talking." I wasn't sure why she said that, so I looked round at her, and she then explained that the witness who I'd been cross-examining had somehow made his way into our breakout room, and we all stopped while he was he was removed. But it was potentially disastrous to have in what you felt was a isolated breakout room with a client and other lawyers from around the world who were also in on the case, to then realise that that witness who turned their video off was actually listening in. And I suspect this happened because that was a case where we had a tribunal who was not very experienced with remote hearings, and the service provider was not very proactive and had obviously not picked up on or had checked all the breakout room participants, which normally happens at or certainly I try to arrange a dry run before a hearing to make sure all those sorts of things are sorted out. I don't think there was any lasting harm done, but it was a salutary lesson to watch out when you go into your breakout rooms, that the right people are in there and the wrong people are not.
Dinesh, can I just jump in, because there's something that Tim said that I wanted to add to. I was at an arbitration and I was very impressed by how the other side, their team designated a hearing manager. So just like that very sharp associate you have, whom I hope got a high bonus that year. But this hearing manager actually is a really useful idea. You have someone in your team, it needn't be a lawyer, but what that hearing manager did during the hearing was not just ensure, keep track of who's entering and leaving the room. So that person was the Zoom host, but that person also managed the hearing bundles. And that was really useful because, each time the hearing bundles are replaced or amended, there's always broken links. And so this one person was just in charge of all the bundles. And moving forward, that's something that I'm definitely going to adopt. And where I can possibly agree with the other side on a common hearing manager, I think that's something that would be really of assistance, because in that particular hearing, the tribunal secretary was not at all tech savvy. So she ended up relying on the hearing manager to basically administer the whole hearing. And that just left everyone to focus on their jobs as opposed to the technology disruptions. And I think that's something that we can all consider, using as a standard moving forward.
Yeah, I agree with you. It's made me also rethink, especially about bundles. I mean, I was addicted when I was throughout practice to the idea of the core bundle. Find the key documents, use it, put it down, And but recently, like the trial I was just doing in the SICC, the judge we had, Justice Almores, he's alerted me to a style that perhaps I'm a bit of a dinosaur, but it was a bit new to me, and it worked really well. It's since you have technology, you just have one chronologically running agreed bundle. And when you have that agreed bundle, even if it's thousands of pages, as long as you're on an electronic platform, finding the page is no problem. And then you accompany that with your affidavits all being crossed against the pagination of that. And bingo, you're done. There's no more need to be too worried about which is core, which is not, and all that. So I thought, it does work. Yeah. So I think one question, I think we have some questions coming in, and I'd like to invite participants. Please feel free to drop any questions you have into the Q&A and we'll try to pick them up. But before that, I think one theme that's emerging is, as we go out of COVID, hopefully sooner rather than later, what have we learned? What do we think we should keep? What should we not keep? And I think critically, which kinds of hearings do you think it's essential that you need to get back in the same room together? And which kinds is it not? Because I must say, yesterday, for example, when I concluded that week's hearing, I suddenly realized that, some of this, like the witness in Germany, why should he have flown to Singapore to give 1.5 hours, or even if it was 3 hours testimony, whatever for, the hotel cost, the travel cost, and all that. So, because it worked so well. He was sitting in his office, and the only cost was, lawyers send someone to observe, for example. So perhaps I come back to you, Nakul. What are your thoughts on this?
Thanks, Dinesh. So So what have we learned? I think we've learned to be significantly more efficient. People like, I'd call myself a part dinosaur. I think a lot of that has changed. I significantly work off electronic bundles, and I'm significantly more comfortable using technology to go about my work. The one significant change I think that COVID has made is that a lot of procedural hearings which used to happen by telephone will now happen by way of virtual conferencing, because you now have the benefit of actually seeing the other person, seeing the arbitrator, or seeing the judge while you are addressing a procedural hearing. When it comes down to a main trial, I don't think I'd say that it works equally well as when you're doing a cross-examination, when you have somebody sitting physically, across the room. I've had experiences where the internet seems to lag at just the right time when you put a difficult question. The interpreter just seems to sort of go off. And while you turn around and say, well, the arbitrator is noticing all of this, well, the arbitrator is actually going to deal with it significantly much later. And there is very little that you can do. And to that extent, it's a little frustrating. Another part that I found frustrating is trying to confront somebody with a document, because I think when you confront somebody with a document because you think the testimony is inconsistent, and if it's a document that's not on record, to try and bring that through the arbitrator during the hearing is a bit of a challenge. So I think in large arbitrations, which are going to be complex, where there is going to be complex evidence, I think we will end up going to a physical hearing. If you're talking about smaller claims, yes, it's much easier to do it by way of video conferencing, and I think it is a good alternative substitute to do a trial. This really gets me to the last part, which is having substantive oral hearings. I think you can do an oral hearing equally well over a virtual conference as you do it physically, and there I can completely appreciate that there will be significant cost savings if people just don't need to fly into one place to do the oral hearing. The only challenge I think which will always run across will be timing. If you all end up in the same room, you adjust to time and you just work with time. But when you are looking at hearings where you've got people from different continents, timing is a challenge. It is unfair at one level to have somebody start off opening submission at 4 a.m. only because it's convenient and probably the most convenient time that you can find. And I think that challenge can't be overcome just by saying, let's do it by way of virtual hearing. If somebody is going to be prejudiced because of timing, then you would, in my view, have to have a physical hearing to conduct the proceedings.
Thanks. Anyone else want to chime in on this? How about you, Tim?
Yeah, I think one of the issues, and Nakul just referred to obliquely, but maybe I can talk a bit more about, is cross-examination. Because I think for many years, counsel, including myself, have objected to cross-examining witnesses by video link in years gone by. And partly, I think that's because the technology wasn't good enough. And there were all the practical issues that I don't think we really face in the same way today, like how do you get the hearing bundle to that witness and so on. And I think that the experience of many people in the last year has shown that the concerns that many of us had as advocates in cross-examining a witness remotely maybe were misplaced through lack of experience. We've had no choice but to try it in the last year, and I think we've all realised it's not as bad as we might think. And one thing that has surprised me, I've done two relatively cases involving dishonesty or fraud, and I cross-examined witnesses in that context. And really, I think that was one of the areas where I was quite nervous about doing that remotely. But I have to say that it's not so much that you can't do it. You have to come up with a different way. You have to, if you can, exploit the medium, but you just have to cross-examine in a different way. And I think there are cases where you do want that person in front of you. I completely agree with Nakul that sometimes there is no substitute for the dynamic that exists between a cross-examiner and a witness. And in cases where you are going to make serious accusations or allegations of dishonesty, then those are often done best in person, because the tribunal also reads the witness, I think, in a way that doesn't really come across on the screen. But on the flip side, when you are cross-examining someone remotely, you can do a few things that you can't really do in person. One, you can stare intently at the tribunal for their reactions to things in a way which would be really quite impolite, I think, in person. But you can look at the tribunal and see how they are reacting to lines of questioning. And it also applies to submissions that you're making as well. And that's done in a way, or you've got your team members who are assigned to an arbitrator to see how they react to things. That is a very useful thing, I find. Also, you can study the body language of a witness, I think, in a way just as well as if you were in person. Just because they are not physically there doesn't mean that you can't do that. What you lose, I think, is that personal interactions with a witness, that sense of developing a rapport with someone as you cross-examine. That's what's lost. But you can try and make up for other ways. But I think we've all probably experienced that in different ways. But for me, that was one of the big concerns I had with cross-examining remotely, but it's to a large extent proved to be unfounded.
Tim, yeah, what you brought up about questioning a witness is something just came to mind straight away. You know, normally when I've been doing in-person hearings, all the time when there's transcription, it always comes up that at some point or another, the transcriber would always say, "You're talking over each other. Please stop. I can't follow." And it comes, now I come to think of it, that did not happen the whole of last week when we were virtual, because I think a self-discipline came in because there's time lag. So in a way, for that series of questioning, the witness would wait for the question because there's no choice otherwise. You know, so actually, in a strange way, it perhaps worked better. But I think you're right. It depends the kind of witness, the kind of testimony you're trying to elicit, and so on. Yeah.
And I think also the reality is that so many of us have been communicating outside a courtroom on Zoom with family members and so on. We've become accustomed to that delay and that need to wait. So I think we've all become better at that, which I agree. I've far fewer problems with talking over in remote hearings.
Right.
I think I'm just going to jump in again.
Smitha.
On the witness point, one of the things that I've noticed is I think it's quite important to, if it's your own witness, I mean, not for the other side's witness, but for your own witness, to sort of practice with the witness where they are looking when they are pulling up the document. So they're using one screen or two screens, because this is actually feedback I got from an arbitrator who told me that at first the tribunal had thought the witness was a bit dodgy because the witness kept looking off screen. And then they found out, I mean, luckily, I think the lawyers on the team realized that the tribunal was how it was coming across during the hearing. So they actually explained to the tribunal that the witness was using two screens, and the screen with the documents was slightly off where the camera was. So it looked like the witness was looking at someone else for answers, but he wasn't. It's just the angle of the camera. And the other reason why this arbitrator told me the other reason why they thought the witness was slightly suspicious was each time, or very often during the cross-examination, his phone kept beeping. So he kept looking at messages. So it looked like he was being coached. But actually, if you think about it, I mean, everyone's phone is, I mean, I'm sure during this session, all of us have received a lot of WhatsApp messages, and it's very obvious when you're looking down on your phone. So small things like that, and witnesses are not people who routinely participate in hearings. I mean, they shouldn't be. So these small things, I think, can really help with the whole impression created and demeanor, so that when people try to read body language, you're not thrown up by what's really very innocuous, innocent things that somehow on screen come across as slightly nefarious.
Thanks, Smitha. We're getting some questions, so let me try to pull some of them up. One question from Vinod Agarwal is, can you share your views on transcripting live as an advantage in virtual hearings? And do they help substitute do they help the tribunal to arrive at their decisions? So I think definitely that's a very useful tool. I think in my hearing, we had it, and a live transcription that was going on, and it also helps clients. So sometimes you don't want to fill the Zoom hearing room with everybody there, so you give the non-participating parties who have a right to follow a transcription link, and I think that's a good way of it working. Anyone else have thoughts on that?
I think the approach of conducting hearings virtually is best suited for a transcription that is live. I mean, if you try and do it the other way, which I wouldn't call it the traditional way, it's very country specific of using manual transcription. That can just make these hearings even longer and more painful than they need to be. So I think while parties may, in the beginning, start thinking about cost related to engaging a live transcription service. But I think overall, in balance, it really adds to the efficiency and the process becomes a lot more palatable for everyone involved.
Right. And another question is, two questions have come towards you, Timothy. One is, don't you think AI can analyze body language better than humans and display it on screen? And another one is, as you mentioned regarding the service provider, do you think the arbitration agreement can specify the platform to be used and its procedure? Wow, any thoughts on that, Tim?
Okay, let's take the first one, AI and body language. I'm not aware whether AI is it sophisticated enough to read body language? I don't know. I think we are as susceptible to get it wrong as anyone else. When I talk about body language, it's hard for me to encapsulate what I mean by that. But to give an example, I was doing a case last year where we had I had planned a relatively tricky cross-examination in a case where we didn't have a very strong case. And there was one line of questioning I wasn't quite sure whether I wanted to approach in one particular direction or another, depending on how the tribunal was reacting and responding to earlier questions. And so my team were all looking at the arbitrators, and we agreed that they would let me know whether we should go down the more aggressive line or the other line, depending on how they were responding. And it was very clear to me, I think, that the tribunal was interested in this particular line of questions, which were more accusatory, just from the way in which they were engaging, I guess in the same way that we see arbitrators engaging in in-person hearings. But for some reason, when you're on the screen, you can stare out the witness, stare out the tribunal. It's hard for me to describe really, but you can look at that arbitrator and think, they're bored by this line of questioning, so I'll move on, or something like that. Whether IA can replicate that, I don't know. If they get to that stage, and we may find ourselves out of a job. But yeah, so very interesting question. I don't know. We'll see how things unfold in the coming years. The second question, I can't remember what the second question was now.
Well, I think that one actually is about whether you can put in your agreement what platforms you're using. Well, I think you can, but I think you can, but I wouldn't recommend it, because I think that things change all the time, and what is good today may not be good in 6 years' time when your dispute arises. In practice, what happens is that this is something that ought to be agreed at the first procedural hearing if you're anticipating a virtual hearing at the beginning of the case, or if it looks as though a case is going to be conducted virtually or in a hybrid format as the case progresses, then I think the tribunal ought to hold a hearing and discuss those sorts of things. The reality is, again, now we are all so much more experienced in different platforms and what works and what doesn't, that those sorts of things ought not to be in an issue. And certainly from the perspective of being an arbitrator, I've never had a difficulty with parties not agreeing on a platform. And I think I've conducted them under Zoom, Blue Jeans, and Teams without any problems. So I think it ought not to be a contentious issue. Thanks, Tim. Tongue in cheek, before I pull up the next question, virtual virtual decisions, AI. This is Premier League weekend, and I'm still not convinced by the virtual assistant referee. So I don't know about the rest of you. But now, moving on to a question from Franz Caps. We've been discussing this theme. In your opinion, will virtual hearings remain as prominent as they were during the COVID-19 pandemic? Clients now tell us they appreciate the cost savings of virtual hearings. Senior arbitration practitioners, on the other hand, have been saying that in-person hearings are the gold standard and will return after the pandemic. What's your take? Perhaps Nakul and Dheeraj, from an arbitrator perspective, what do you think?
I think for small value claims, I think virtual hearings will definitely become more and more relevant and more prevalent. But I think we can come back to large value claims where you're looking at people from multiple jurisdictions, where timing is going to become an issue. If you're going to look at a 2-3 week trial, I think people will still come back into a physical room and conduct it there. That's my short answer.
Yeah, I think I agree with Nakul there that while we're all adapting to this entire online hearing, but the real excitement of that cross-examination and the trial is missing. And I have personally come across clients who have actually said that, why don't we try and defer these proceedings to a later date so that we can still try and get the trial in physically if possible. So maybe large claims where trial will be there, people would probably still prefer to have the physical hearings. Of course, in terms of arguments and the final closings, etc., all that can still be done online. But I think the trial is the most important place where people would really want to get into a physical hearing again.
Right. Chaitanya, what are your thoughts on this this whole thing about what you keep, what you don't need when we hopefully come out of this?
Dinesh, I think it's not a clear-cut answer to me. I think there are some things that will remain physical, and there are a lot of things that will move to a virtual platform. And I think a little bit of that will depend on how this experience pans out at the end. I mean, there are a lot of hearings that have been done entirely virtually. And if at the end of this process, you end up with an outcome that is acceptable to parties and counsels and others involved in the process, equally as much as it would have been if it was done in a physical format, then I think the question will be asked whether the need to get people in the same room and fly them around the world and accommodate them in hotels, etc., is there, or if the cost savings that parties have experienced is significant enough to continue to demand these hearings to be held virtually. I mean, I'll share an example. We were conducting, but I was a part of a hearing that was 3 weeks long back in January. And during the process of taking expert evidence, the tribunal realized that some parts of the factual witness needed to be re-examined. And we asked for the factual witness to be called again. And the opposing counsel said, well, we can make them available in 30 minutes. When the witness was made available, the individual was being driven from their office to their home by a chauffeur in his car. And he was sworn in while in his car, and his evidence was taken, and he was cross-examined over the next 45 minutes. I mean, that sort of efficiency in a pre-COVID environment would not exist. I mean, it was unheard of to have this sort of a efficient process be acceptable in terms of confidentiality, in terms of its entire demeanor previously. And if it does become effective, then I think parties will question the need to bring this witness or similar witness out to Singapore and spend a week in doing so.
Thanks, Sarshana. I think one space we all have to watch, and I think how much technology has been able to stand in the gap this last year has been amazing. And I think that now that the potential is seen, I wonder what technology development companies and investors are thinking about giving us those, something even better in terms of virtual hearing centers and what that means about the physical hearing centers and that whole metrics. I think that's another thing to watch. But I'll move on to another topic. We have about 10 to 12 minutes left. Ultimately, in arbitration, we're all looking to have an enforceable award. And as I was saying before, when you talk about the dogs barking and all sorts of things happening, due process, the role of due process, and you have the New York Convention interplay with different standards, different due standard processes, and so on. And one thought come to mind. I'll throw up one hypothetical, and please feel free to give your thoughts on the hypothetical or any other aspect of this question, of how technology may be a boon or bane to this. If you were an arbitrator, for example, and let's say you were doing the hearing in Singapore, and one party is physically available to attend in front of you, or one witness is, for example, and one isn't. What would you do protocol-wise about that sort of thing? Is it something you would just go ahead with? Anyone want to chime in on that? Nakul? Tim, yeah, go ahead. Yeah.
I was going to say that I was going to chime in because this actually happened to me in March last year. So just before the shutters came down, I was sitting as a sole arbitrator on a matter, and we were due to have a hearing, 5-day hearing with, I think, 9 or 10 witnesses at the end of March. And it became apparent that countries were going to be closing their borders and that there was going to be some sort of lockdown in various countries. And so we had to decide what to do. Were we going to defer it? Were we going to have some of the witnesses who were in Singapore, some were in other countries? How were we going to proceed with this? And in that case, neither party wanted to adjourn, so we proceeded, and we had a hybrid hearing at Maxwell Chambers in Singapore. And in terms of having witnesses in different countries, I didn't see that as a due process issue. as long as, of course, the witnesses could be examined to the satisfaction of the parties. There was an interesting question as to whether the expert witnesses could be hot tubbed, so that could there be a witness conference where one of the experts was outside Singapore and one of them was in Singapore. And ultimately, I ruled that there wouldn't be a conference in that situation, although I was, it was a difficult one. I just felt it wouldn't be fair to both witnesses if one was in front of me and one was on the screen. But ultimately, it turned out that the witness who was in Singapore had to fly back to the UK because of the borders shutting. And so it ended up they were both remote. But I still didn't order a witness conference because, again, I thought it was just better for the parties in the circumstances of that case. They'd just be cross-examined in a normal way. But it is an issue. And I think the issue crops up or has cropped up more in terms of parties wanting to defer hearings on the basis that it's only proper that there should be an in-person hearing. And there's been some helpful indications, I think, from the English court. There's a couple of judgments in the English High Court which I've used and referenced to get parties over the line to hold a virtual hearing on the basis of due process concerns. But it's a difficult one. You have to see what each party wants, and often, that they will disagree because one party has a different agenda. And that actually raises a point that when Nakul was speaking, I was thinking of another point, which was, many people have said that where you have a large hearing or very important hearing, and you really want to have that person in the room to cross-examine, don't forget that the counterparty may use virtual hearings as an argument to avoid that very incident. So there may still be these discussions, even though everyone might accept it's a very big, important hearing. Strategically, parties may actually the other way say, no, actually, I think we should do this virtually.
Yeah, I mean, I've been in that position myself about deferring availability of the witness as an arbitrator. And I found myself as the arbitrator instinctively reacting by saying to the other side, well, do you consent to this? Because I wanted to know upfront, because I was thinking, about the road ahead. Yeah. Anyone else want to comment on this issue?
Yeah, Dinesh, I just wanted to bring up,
okay, Smitha first, then Nakul. Yeah.
Similar to what Timothy raised, there was actually something earlier this year, at the start of the year, I think it was the boundary dispute in the Indian Ocean between Mauritius and Maldives. And one of the issues, it was that it lost special chamber tribunal. And one of the issues that came up there was whether it was fair. This is on due process. And the issue was, the allegation was that it wouldn't be fair if I think the Mauritius judge participated remotely and the Maldivian judge participated in person. And that actually became an issue and has become the subject of quite a lot of academic debate. And if I recall correctly, where it landed on was they found a basis for allowing a hybrid hearing, so it was fine, but it has left a lot of people unsettled over whether on the fairness element, whether this is within the rules and whether this does affect due process. So even from the tribunal's perspective, I mean, parties, I can see why, there's this perception if you've got one physical arbitrator sitting there and your choice of arbitrator, your nominated arbitrator is sort of like distant or remote, literally remote. I think that just creates a certain perception for the conduct of the hearing.
Nakul?
I just have a very short point. I mean, this entire concept of due process as being one of the grounds that we always try and protect in an arbitration is something that's developed over, I think, a number of years. I mean, it's not something that's developed over two or 3 years. It's been going on for the last 50 or maybe 100 years. You have moved into a new system. But in that new system, I think it's very early for us to say that a virtual hearing and a physical hearing or a hybrid hearing all result in a level playing field. So the way I see it is that you have to have a level playing field. It may be convenient to say, I'm sitting in Singapore, one arbitrator is sitting in Singapore, and one witness is sitting in Singapore, so the three of them can be there physically, and somebody else who's outside is going to be there virtually. I think you have to have a level playing field where if you're going virtual, everybody goes virtual, even if it's convenient to do it some other way, which is to say partially virtual and partially physical. Or if you're going physical, then you go physical. In time, I think when people get more comfortable with technology and we all come to take the view that having a virtual hearing is as good as having a physical hearing with really no difference, then perhaps you could look at these convenient mechanisms. But I think until then, I would err on the side of caution and adopt a level playing field and have the same system apply to everybody. The only
Thanks, Nakul.
additional point I would make is unless parties agree otherwise.
Right. There's a couple of questions just come in on the chat section. Let me pick those up. Firstly, a question from Sunita Advani. She's asking a question to Nakul and Timothy. Have you found that the directions set out in the virtual hearing protocols were sufficient in the hearings you attended? Or are there any particular considerations that you think should have been included that were not? Any thoughts here?
Example. I mean, I'm happy to give you a short example on this. So we ended up with a virtual hearing recently. This was sometime in February. And the service provider, which is a very well-known service provider, had a software which didn't have a witness breakout room. So if you were cross-examining and you wanted the witness to leave the room so that you could have a discussion with the tribunal, there was just no way of putting the witness into a breakout room. And that was not specified in the protocol. And we couldn't do anything through that 5 days of hearing, which was a bit of a pain because the witness literally had to be asked to leave the room physically. The connection shut and somebody had to call up the witness and said, please come back and rejoin. I used the same provider 4 weeks later, and I think the service provider sorted that out by using a different software. But yes, I mean, that was one deficiency that I can look at.
Right. And there's another comment from Saptak Sanyal asking all the panelists to avoid due process challenges to virtual hearings. Do you think some changes in institutional rules will help? I think this is a big one, one that the MCIA and the SIAC may need to have a think tank over. But it goes to the very topic that we're discussing, I think, on the making sure due process is still followed. Otherwise, everything, you're at risk of losing confidence. Yeah. Anyone else have any comments on any particular topic? We have a couple of minutes left. Anything you would like to say, Smitha? Any more comments on due process or so on?
Maybe I can add on to Nakul's point about that in response to Sunita's question of protocols. As probably everyone knows, there are hundreds. I'm sure there are hundreds of virtual protocols now floating out there. There are lots of different ways of doing it, and I think that it would be quite a difficult task to go through all those and find the bits that do work and don't work. And I found, both from the council perspective and as an arbitrator perspective, sometimes it so much depends on the parties and how experienced they are in virtual hearings, how antagonistic they are, the different levels of cooperation on different cases. And I think as an arbitrator, you've got to find your way through that and see where the points of commonality are and see what you can cover sensibly at a procedural hearing, I think, and off the back of that then issue directions. But certainly the virtual hearing protocols that I've seen by various institutions I think are all very helpful. They all cover different bits, so it's hard to say, but I've certainly used them in different hearings.
Well, we've got one final question. How authentic, from Mr. Jain, how authentication of deposition is done in an online examination usually? Anyone want to pick that up?
Dheeraj, do you want to have a go? Because I think it's more of, it's an Indian question, but I'm happy to answer it. I mean, I think Mr. Jain is coming from the perspective of authentication of the document which records your evidence. And how do you do it? Because what happens is in India is if you do a cross-examination, the witness is sitting in the room, the witness then signs the deposition and the arbitrators confirm that deposition to be the accurate deposition. Now, in an online scenario where everybody's sitting separately, if you have live transcription, how do you do that? Well, just last week when the Supreme Court was in recess, I was doing something similar where we had live transcription. And what the arbitrators did and said was, he said, let the live transcription come out. We will take those pages of the transcription which deal with the evidence and have the witness sign every page. And I will affirm that, and I will then countersign every page and say that's the authenticated document. So yes, there was a way which was used.
Thanks. Well, that brings us to the end of the time. It's been a quick hour that has flown by. It remains for me to thank once again MCIA and SIAC and all our speakers, Chaitanya, Smitha, Dheeraj, Nakul, Tim. Thank you all for your time. And to all our participants, thank you for being with us. Thank you.
Thank you.
Thank you.
Thank you very much to all our panelists for your insights, for your wisdom, for your anecdotes and your commitment to your job, even at odd hours across continents from cars and hospital beds. Most of all, thank you for your honesty and humor. Kids, teddy bears, exotic birds, dogs, and whatnot. These war stories have confirmed one thing, that arbitration hearings will always be eventful, and a screen is not going to confine any one of us. I am sure I echo all when I say that this was an absolutely fantastic session, and we have a lot to take away from this. So thank you very much again to all of you. Please also join us back at 3 p.m. For the next session, which is Global Perspectives on Recent Developments in India Related to International Arbitrations, hosted by DLA Piper. Thank you very much, everyone.
Thank you.
Have a good afternoon.